Hello. Here we go. Sorry, everyone. I'm just getting things put together here. There we go. Whew. All right. Ah! It's all falling apart. Oh my goodness. Hello. I'm sorry. Sorry I'm late, everybody. I'm trying. We're almost there. Hold on. We need some light. There we go. Wait, nope, no light yet. Hold on. Oh my gosh. Oh, goodness gracious, everybody. All right, here we go. All right, so this is on. And then, oh no, is my light not working? Oh my gosh, everybody. All right, hold on. I think I'm gonna have to stop doing the pregame lives because it's just it's too much pressure. All right, here we go. There we go. Now we got the light. Oh, fabulous. All right, excellent. Yay! Welcome in, everybody. There we go. Welcome. Whew. All right, and I do have my other microphone. So if there is any crackling, let me know, everyone, so we can try out my other microphone. I'm very excited about it because that's where I'm at in my life, right? Oh my gosh. Hello. All right, let me see. Am I centered? I need to go back a little bit. There we go. Whew. All right. Hello. Or maybe cut 10 minutes early. I know it's so hard. It's my own fault. I just have so much fun chatting with everybody. I just think in my head ooh, one more question. And then 20 minutes later, I'm like, oh dear. My cats are running out of the way as I'm heading to the other room. My family's like, get her computer now. Oh my goodness gracious. Yes. Well, welcome in. Welcome to the show, everyone. Oh my gosh. Yes, Heather. So she did not hold anybody in contempt, but on the other hand, one thing to keep in mind is that this was more of an evidentiary, it was not an evidentiary hearing, I apologize. This was just supposed to be an update to update the procedures, right? So the defendants are supposed to be putting in status reports every day. That's what this hearing was for. And for me, she has set out a couple of other hearing dates and a couple of other due dates. And I'm thinking if she had gone through the contempt process, they would have appealed because they didn't have proper notice. So I think that's probably what happened here. I think she's willing to do contempt. I think she just wants to make sure that everything's just done perfectly. Because this case is crazy, right? Homegrown. Yeah, well, I mean, that's kind of the language for jerks. All right, now let's see here. Hold on a second. Somebody was saying the Republicans were suspending. Hold on a minute. I didn't even have a chance to pull it up. Republicans suspending constitutional authority. I can't imagine. I just can't even imagine that. Let me just look real quick. Yeah, I don't see anything. That's void. Okay. Well, it was definitely worrisome. We don't want to hear anything like that. I'm not even sure it's possible, but right. She doesn't want to miss a step. Exactly. You have to, these cases, everyone, have to be done perfectly. Absolutely perfectly. Every step along the way has to be perfect. And with their eyes towards the Supreme Court with every order to make sure everything's done correctly. Right. If he doesn't do what they say, what's next? Great question. And I'm not 100% sure. I mean, we've got right now in DC, we have the JGG case. We're still waiting for the judge to issue an order on the show cause hearing. So we're still waiting on that right now. That will give us the best indication of what's going to happen, because if he finds that they are in contempt in JGG when he said turn the planes around and they didn't, that's really going to be the most powerful position to stand on when going forward on contempt. I think it would be in everybody's best interest for that case to be the one that we work through what we're going to do with contempt. Right. Okay, ready to study. Hello, welcome in. All right. Couldn't find any match on it. Yeah, I didn't either, but there just isn't, you can't really suspend your constitutional authority. Like, even if you wanted to, quit your job, it would be up to the governor of your state to appoint someone to take your position. So there's really not much you can do when it comes to statutorily what's written in there. Oh, thank you so much. Cocoa latte. Oh, we love that. His entire cabinet. Yeah, El Salvador. Yikes. All right, everyone, welcome in. I apologize for my rushed run across my across my home, scaring my cats. But here we are. So today we did have a couple of things that were filed. So for everyone who needs an update, I've been going through the Garcia case, right? This is the case involving Mr. Garcia, who was picked up even though he didn't have any reasonable suspicion or probable cause, no criminal history. They picked him up and they shipped him out to El Salvador. Now, what's unique here is that the attorney for the Department of Justice said, whoops, we made a mistake. And based off of that, then, we're in court now trying to see how to get him back. So the district court here had said, we have a restraining order, you need to bring him back. And it went up to the U.S. Supreme Court, and the Supreme Court said, you need to follow the district court's order. And district court, you need to, firm things up a little bit, which she did. So she firmed the language up a little bit and then said, I want daily status reports. And so that's kind of where we're at. Today was a status report conference. So that's what the hearing was for today, was to see, like, well, where are we at here? And the status reports that have come in have just been declarations from various people with like no information at all, not useful at all. But which, that sucks, but I'm not surprised again. So these declarations have gone in. The plaintiffs had made a special request saying, we want discovery. We want to see what's this contract between the US and El Salvador. We want some information. So they had set out a couple of things that they wanted, and defendants had said, no, you're not entitled to any of that. It's all classified. It's all information that you're not allowed to have. So we're not going to give you any information. So then the plaintiffs today have filed a reply. So I'll go through that. That's only a couple of pages. So they come back and answer all of the defendants' pieces. And then we have a filing from the judge. She has filed a letter order to, oops, sorry about that. She has filed, I'm a little bit off. This is March. Hold on. Let's go back. We're in April. Here we go. That was my cat. I apologize. She has filed a letter saying, these need to be the protocols for discovery. And then she's also issued an order for expedited discovery. So we will be going through that tonight. I had pulled out and printed out some of the other paperwork on this case. So I have the original, I'll just show it to you here as I clear the path. This was the preliminary injunction here, which was part of what was being appealed. This is the notice about appealing. This is the, here, this is an amicus brief by Erwin Chemerinsky, who's like the the really, really smart constitutional law person, very highly respected. So we have our Court of Appeals Fourth Circuit decision here, and then as I flip through to get us to where we need to be for today, here we go. Now this is, hold on here, let's get my paperwork sorted. Okay, 21 and 21. Right, so this is an emergency preliminary injunction piece of that case. We have the order here on the 10th, again, from the judge setting out the in-person conferences that we've had and various other things. Again, this is just a procedural history I'm taking you through here. And we've got a 2-page order here. Status conference, that was on the 11th. All right, and then this is the filing from today. This is the plaintiff's reply, again, in support of the plaintiff's motion for additional relief, which they had already filed. Defendants have said, no, we don't want to do that. And I did pull the original writ of habeas corpus as well, which was filed yesterday. And I think if my cats had thumbs, they would be my paralegals, but they don't. So I can't live in that dream world. Have to face reality at this point. Oh my gosh. Yes, the taxpayers pay for it because it's the Department of Justice. And not only do they pay for it, but they also are pulling attorneys away from all the other cases going on in the Department of Justice. All of those federal criminal cases are having, their cases are collapsing, basically. All right, so here's the order today, granting expedited discovery. So these are the documents I want to go through. Again, the pleadings, we've got plaintiff's response here, and then we have one order for expedited discovery, and then a clarification letter from the judge. All right. Right. Yeah, exactly. All right, so here we go, everybody. Let me get my sticky note out. So welcome in. For anyone who is new, I am a licensed attorney, and I have worked for a very long time. The areas I focused on were criminal law, evidence, constitutional law, so some appellate work, along with, some civil litigation as well. I think a lot of people think attorneys will specialize in a particular area, but if you are an attorney in more of a rural community, it's kind of like a general doctor, right? So it's kind of a little bit of everything, depending on who needs you and what needs to be done. And then we'll refer anything that's outside of our wheelhouse out to other attorneys. So dabbled a little bit in everything. And then I have taught for years and years and years. And I've taught criminal law, constitutional law, evidence, torts and litigation, legal research and writing, all of those kinds of courses as well. So, but now I come here and I talk about all this crazy stuff going on in the world. So that's where I'm at currently. So tonight we're going to dive back into the Garcia case. Now, I know there's a lot of stuff going on out there, everyone, that is not the Garcia case, but this one's kind of the big one right now. So this is kind of the biggest deal. We did have, has anyone heard about the Weinstein update today? They're supposed to be picking a jury in New York for his retrial, and I've not been able to find any updates on that. If anyone knows what's going on with Weinstein today, you can feel free to share. All right, so we're dealing with the Garcia case here. Oops, I already spelled it wrong. See, you make mistakes when you rush. Gotta slow down. Oh my gosh. All right, so Garcia. So were some of you able to go and listen to the reading I did of the 2019 judicial order from the immigration judge? I'm just curious. That was really eye-opening for me to be able to read through what that order in 2019 said, because a lot of the facts were very interesting. Right, jury selection started. Okay, yeah, that's what I thought. That's what I thought. Okay. Yeah, I mean, I thought it was very interesting how the judge worded things, and the fact again that the request that he was making for basically being able to stay here was under the law. I mean, that's one of the things in the legal system that they're allowed to do. So, Snappy, no, I put it, it's about a 30-minute, I mean, you can fast forward it. I recommend fast forwarding it. It's about a 30-minute post, and I've read through, it's a 14-page order from 2019, and there's no way I would be able to say a lot of those words on the TikTok, so that's why I put them over here. So, really kind of focused in. Okay, good, good, good. Yeah, yeah. No, he's not a criminal. He doesn't have any record of any criminal activity. We're not saying, well, oh, he's not been a felon. No, he's got none. He's got absolutely none. So let me start here, and I'll just put updates on here so people know what we're talking about today. This is the plaintiff's reply again in support of plaintiff's motion for additional relief. So I will go ahead and read through this. It's very, very short. And again, the plaintiffs were requesting additional information and wanting to give a couple of suggestions on how to get him out of El Salvador and what that could potentially look like. So there were some requests in there. The defendants came in and said, you're not getting anything you're requesting, and the judge should not give you anything, and we're not even going to listen to you, judge. So this is the plaintiff's response to that. Plaintiff's reply in support of plaintiff's motion for additional relief. The government contends that the term facilitate is limited to removing any domestic obstacles that would otherwise impede the alien's ability to return here. Not so. The Supreme Court ordered the government to facilitate Abrego Garcia's release from custody in El Salvador and to ensure that his case is handled as it would have been had he not been improperly sent to El Salvador. Direct quote. That order is rendered null if construed solely to require removing domestic obstacles. To give any meaning to the Supreme Court's order, the government should at least be required to request the release of Abrego Garcia. To date, the government has not done so. Contrary to the government's assertion that it lacks authority to take any such actions, its own ICE policy directive requires DHS supervisors to fully coordinate at the international level to facilitate the return of removed individuals. And this is incredibly powerful right here. So the government continues to say, well, we can't do anything. We can't do anything. And so the plaintiffs have put out in here, in their directive, in their own operations manual, it says here, 11061.1, facilitating the return to the United States of certain lawfully removed aliens. So they have a full section here on that. All right, next, the Secretary of, yes, this whole situation is absolutely atrocious. I agree. State announced that the government delivered an additional 10 detainees to El Salvador on Saturday. Now, at least they're telling us we had 10 here. Now, footnote 2 is where there's quoting again the current policy facilitating return, noting that ERO, ARO, HSI, and OPLA supervisors must fully coordinate at the local, international, and headquarters level to effectuate this policy. So they allow for it. It's written in their rules to bring people back. That involved all three of the actions that the government contends the courts cannot order. 1, making demands of the El Salvadoran government. 2, dispatching personnel onto the soil of an independent sovereign nation. And 3, sending an aircraft into airspace of a sovereign foreign nation. The government holds contractual rights to send prisoners to its contract facility where the United States has outsourced part of its prison system, and it holds the power to secure and transport its detainees, Abrego Garcia included. It can exercise those same contractual rights to request their release, as the detainees are being held pending the United States' decision on their long-term disposition. So this is another thing that we've been talking about. There was no specification on how long they were going to be there. And there was this idea of, well, who decides if this is forever or just for a few years, right? That's a huge issue. Since this court's April 10th order on remand clarifying that the government's required to take all available steps to facilitate the return of Abrego Garcia to the United States as soon as possible, and this court's April 11th order requiring daily updates, the government's updates do not indicate that any steps have been taken to comply with this court's and the Supreme Court's orders. There's no evidence that anyone has requested the release of Abrego Garcia. And again, that's important. Like, no one's even asked. I mean, the president person got asked by the press, but, who has anyone in the government asked? And then this is their signature. Counsel for the plaintiffs. Again, this was filed today. So that was the plaintiff's response to what the defendants were saying. Oh, we don't have the ability to go onto foreign soil or even fly into the airspace to get it. The El Salvador fella, I don't remember his name. I'm terrible with names, everyone, especially for people that I don't care to know what their names are. Sometimes it's extra hard in those cases. Oh my goodness. All right, here we go. This is the order that came out of the court today, everybody. Now, again, this hearing was not something that we could listen in on as the public. If you were there, then, you could go, but we did not have the ability to listen, unlike the JGG case. So this was, all we got was this order here. We've got filed today in the U.S. District Court, District of Maryland, which is where this case is. D.C. is the one for the JGG case. An order granting expedited discovery. Pending before this court is Plaintiff Kilmar Armando Abrego Garcia's motion for additional relief, requesting expedited discovery of the government's actions or failure to act to facilitate his return to the United States and other interventions. Specifically, Abrego Garcia seeks discovery as to the terms of any agreement, arrangement, or understanding regarding the government's use of CCOT to house U.S. deportees, his current physical location and custodial status, and what steps, if any, the government has taken and will take to facilitate Abrego Garcia's return to the United States. Defendants oppose this request, principally contending that the proposed relief is not consistent with the Supreme Court's order or the well-established meaning of facilitating returns in immigration law and harbors fundamental constitutional infirmities. I do like how this judge writes. I do have to say that right off the bat. For the following reasons, the court grants the motion of expedited discovery as directed below. The court defers its decision on the remaining request for relief. So the rest of what they were asking for will be put on pause. Rule 26 of the Federal Rules of Civil Procedure provides that parties may obtain discovery regarding any non-privileged matter that is relevant to any party's claim or defense and proportional to the needs of the case. In ascertaining whether discovery is proportional to the needs of the case, the court must consider the importance of the issues at stake in the action, the amount in controversy, the party's relative access to the relevant information, the party's resources, the importance of that discovery in resolving the issues, and whether the burden or expense of the proposed discovery outweighs its likely benefit. Upon a showing of good cause, the court may permit discovery where significant questions regarding non-compliance with a court order have been raised. So here's your contempt piece, everyone. And we're citing the Leavitt case and Palmer, allowing discovery where without it, plaintiffs would not be able to determine whether the government has complied with the court's injunctions. The Blackberry case here, granting discovery where plaintiff raised serious questions regarding defendant's possible violations of the preliminary injunction. So we love this. Anytime we can have cases that are exactly the same as what we're asking, We love to have that. To ascertain whether the good cause standard is met, the court considers the following non-exhaustive factors. 1, whether a preliminary injunction motion is pending. 2, the breadth of the requested expedited discovery. 3, the proffered reasons for the expedited discovery. 4, the burden on the opponent to comply with the request for expedited discovery. 5, whether the evidence sought could be obtained more efficiently from some other source. 6, the extent to which the discovery process would be expedited. And 7, whether a motion to dismiss for failure to state a claim is pending. And those different elements are pulled out of the Courthouse News Service versus Harris case here. It is undisputed that Abrego Garcia is entitled to injunctive relief for the reasons previously discussed and affirmed without exception. Citations to that. Oh, are you asking me to help you with a civil case? I do not take clients from social media. So apologies, but I just don't pull clients in that way. As to the scope of such relief, the Supreme Court of the United States unanimously affirmed that the district court's order properly requires the government to facilitate Abrego Garcia's release from custody in El Salvador and to ensure that his case is handled as it would have been had he not been improperly sent to El Salvador. To that end, the Supreme Court forewarned the government that they should be prepared to share what it can concerning the steps it has taken and the prospect of further steps. So again, this is our judge saying, this is what the Supreme Court said, so you need to do it. Here we go. We've got a concurring in Wilkinson. In this situation, I think it legitimate for the district court to require that the government facilitate the plaintiff's return to the United States so that he may assert the rights that all apparently agree are due him under law. It is fair to read the district court's order as one requiring that the government facilitate Abrego Garcia's release rather than demand it. So that's another piece of trying to figure out what exactly that facilitate means here. Sorry, tea break, everybody. I had to switch back to tea from Tang. I was having too much Tang. This court in turn ordered no more than what the Supreme Court endorsed, that defendants take all available steps to facilitate the return of Abrego Garcia to the United States as soon as possible, because bound within this remedy is Abrego Garcia's release from custody and the assurance that Abrego Garcia's case is handled as it would have been had he not been improperly sent to El Salvador. And she's again quoting the Supreme Court's decision. To advance that remedy, the court required swift disclosure of that which stems most obviously from the Supreme Court's affirmance. 1, the current physical location and custodial status of Abrego Garcia. 2, what steps, if any, defendants have taken to facilitate Abrego Garcia's immediate return to the United States. And 3, what additional steps defendants will take and when to facilitate his return. This information is wholly consistent with ascertaining what, if anything, the defendants have done to facilitate Abrego Garcia's release from custody in El Salvador and accord him the process due had he not been improperly sent to El Salvador. Oh, thank you so much. Woody versus Woody. That's funny. Wow, thank you. I appreciate that. Notably, to facilitate means to take the occurrence of something easier to render less difficult. And she's citing a Black Laws Dictionary. We love that. Merriam-Webster defines the terms as to make easier to less difficult, to free from difficulty or impediment. Going on, there's a citation for Webster. Oh dear. You know, when they get the dictionaries out, they're not happy about the situation. And the Oxford English Dictionary defines facilitate as to assist a person, to enable or allow a person to do something, achieve a particular result, etc., more easily. And then there's her citation. Defendants therefore remain obligated at a minimum to take the steps available to them towards aiding, assisting, or making easier Abrego Garcia's release from custody in El Salvador and resuming his status quo ante. Ante? I think that's better. Oh my gosh. But the record reflects that defendants have done nothing at all. And that's very true. Instead, the defendants obliquely suggest that facilitates limited to taking all available steps to remove any domestic obstacles that would otherwise impede the alien's ability to return here. The fallacy in the defendants' arguments is twofold. First, in the immigration context, as it were, facilitating return of those wrongly deported can and has included more extensive governmental efforts endorsed in prior precedent and DHS publications. And then we have a footnote here. And I think, again, it's really smart. It's a very smart move to pull in other cases where, you know, they are like, whoops, you went to the wrong place and went and got them. So here's number one, footnote 1 here. For example, in this case, here, the litigation centered entirely on the government's practices and policies for returning wrongly removed non-citizens to the United States for further immigration proceedings. In connection with that litigation, then Deputy Solicitor General Michael Dreeben clarified for the Supreme Court the government's policy and practice of facilitating return after removal. Here, as Dreeben noted, although the government's efforts varied depending on the circumstances of the case, its ultimate objective was to effectuate return, which could include steps such as granting parole and sending a cable to the consulate or embassy nearest to the alien, which instructions to issue, a travel document to avoid uncertainty and how to achieve return. Then Director of U.S. Immigration and Customs Enforcement, John Morton, implemented notice procedures, designated points of contact, and engaged the government's diplomatic channels worldwide to take additional steps to further improve facilitation of return if necessary or appropriate. So again, they're just going through and explaining, like, y'all have done this before. In one instance, the government engaged the ICE attaché in South Africa to facilitate the return of a removed non-citizen in Ethiopia. In another, the government worked with the U.S. Embassy in Tokyo to secure a return. And yet in another, the government facilitated the return of Joe Desire from Haiti with assistance from the United States Marshal Service, which manned the government airplane that flew to Haiti to retrieve Desiree. And then further citations of how that happens. Lastly of note, discovery generated in that matter reflected the government's practice of logging all efforts to facilitate return as a matter of course. Ooh, so they even have evidence of what they're supposed to be doing as protocol if someone gets put in the wrong place. So that's incredibly powerful information right here. The court cannot credit that facilitating the ordered relief is as limited as defendant suggests. Second, and more fundamentally, defendants appear to have done nothing to aid in Abrego Garcia's release from custody and return to the United States to ensure that his case is handled as it would have been, but for defendants' wrongful expulsion of him. Thus, defendants' attempt to skirt this issue by redefining facilitate runs contrary to law and logic. Woo, that was a burn. Turning to the factors supporting expedited discovery, first, the court already issued preliminary injunctive relief, which remains active and enforceable. Expedited discovery in the instant case accords with the preliminary relief. Second, the requested discovery appears relatively narrow in scope, but unworkable as plaintiffs have proposed. An immediate evidentiary hearing, as the plaintiffs ask. All right, so this is the one we were just talking about, everybody. They'd asked for a hearing to go forward on contempt, and so she's going to be explaining to us, why that wasn't going to work. Elevate speed over effectiveness. Oh my gosh, this is critical right here. Instead, the court will permit discovery as set forth below, adhering to those areas of inquiry the Supreme Court made clear are properly required. So she's basically telling them, let's slow down and do it right the first time, right? So measure twice, cut once kind of situation. Discovery will be carried out expeditiously, but with sufficient time to allow development of the factual record. Third, the discovery is necessary in light of the defendant's uniform refusal to disclose what it can regarding their facilitation of Abrego Garcia's release and return to the status quo ante or present any legal justification for why they cannot disclose. And then we have a second footnote here. Again, this court is ever mindful of the Supreme Court's directive that the court's injunctive relief must be accorded with due regard for the deference owed to the executive branch in the conduct of foreign affairs. But this deference does not mean the court must ignore the defendant's repeated refusal to provide even the most basic information as to any steps they've taken to facilitate Abrego Garcia's release from custody in El Salvador and to ensure that his case is handled as it would have been had he not been improperly sent to El Salvador. Thus far, the defendants appear to have taken no steps and provided no explanation, legal or otherwise, for such inaction. Fourth, the burden on the government's minimal, particularly because, as the Supreme Court underscored it, should be prepared to share what it can concerning the steps it has taken for the prospect of further steps. Fifth, the request for a discovery is timely in that defendants have not yet complied with this court's directives, and Abrego Garcia appears to remain inexplicably detained in CCOT. So let's see what more information we have here. This could be a proof of life moment, everyone. So bump down here to 3. In this regard, State Department official Michael Kozak has attested that Abrego Garcia is detained in CCOT pursuant to the Sovereign Domestic Authority of El Salvador. And yet the record thus far demonstrates that the United States has paid $6 million to house those detainees in custody, pending the, oh my goodness, everybody, the writing's so small. Pending the United States' decision on their long-term disposition. Here, and there's your citation here. Plaintiffs are entitled to explore the lawful basis, if any, for Abrego Garcia's continued detention in CCOT, including who authorized his initial placement there and who presently authorizes his continued confinement. So these are just basic questions. 6, discovery must proceed without delay, as Abrego Garcia is indisputably entitled to the due protections that defendants have denied him, and to be free from the risk of grave injury resulting from his continued detention in CCOT. 7th, the absence of a dismissal motion is of no moment because plaintiff's request for expedited discovery focuses on securing compliance with this court's amended order and other related directives, and in the face of ongoing refusal to comply, to assist the court in determining whether contempt proceedings are warranted. So it's definitely on the table, everybody. I think this is one of those moments where the judge is like, you need to get yourself sorted out. Accordingly, the court will permit expedited discovery to ascertain what, if anything, the defendants have done to facilitate Abrego Garcia's release from custody. I'm kind of askew here. In El Salvador, and to ensure that his case is handled as it would have been had he not been improperly sent to El Salvador. Again, she's back. She quotes the Supreme Court's decision six times. This includes evidence concerning 1, the current physical location and custodial status of Abrego Garcia. 2, what steps, if any, defendants have taken to facilitate Abrego Garcia's immediate return to the United States. And 3, what additional steps defendants will take and when to facilitate his return. All right, now we're going to get into the schedule that she's setting out here for us. Number one, by no later than Wednesday, April 16th, so that's tomorrow at 5 p.m., and pursuant to Federal Rules of Civil Procedure 26D1, 33, and 34, plaintiffs may propound upon defendants up to 15 interrogatories and 15 requests for protection of documents focused on the above areas of inquiry. Ooh, nice. 15, that's pretty good. Defendants shall serve their answers and responses to plaintiffs no later than Monday, April 21st. Whoa, that's quick. All right, so, whoa. So they've got 5 days here to answer 15 interrogatories. That's expedited. That is absolutely a huge thing because it takes forever to do interrogatories. And let's bump down here. 1 interrogatory served on all defendants equals 1 interrogatory for purposes of this order. Likewise, 1 request for production of documents served on all defendants equals 1 request for purposes of this order. So because we have so many defendants, what she's saying here is, and she's very smart to do this, I think. We've got multiple, hold on everybody, let me bump this over here. We have multiple people involved in this entire situation. And so if they're saying 1 interrogatory counts as 1 question, but that same one goes out to all 12 defendants, then they would only have 3 interrogatories left. So I think it's very important for her to clarify everything here because she's going to have to lead them through this whole process because they're, jerks. All right, number 2, plaintiffs may also, by no later than Wednesday, April 16th at 5 p.m., notice the depositions of the following affiants. What? Oh my gosh. So the judge said the plaintiffs can request depositions of these people, Cerna. He did that, the filing earlier, Katz, Kozak, Mazzara. Oh my gosh, this is really important, everybody. This is really important. So the last few days, they've been having to do a status report. But instead, what they've been having are these disclosure statements. Let me see if I can grab one here. Let's see, where did I put it? Disclosure statements. Here we go, here we go, here we go. No, that's not it. Oh, no. Well, all right. Apparently it's not in this stack either. But it's just been a 1 to 2 page written, basically it's like an affidavit where they're coming in and saying, I'm special and important and, nothing's going on. That's basically what they're putting in these different pieces that we're dealing with here. So each of the people that have filed one for each day of the status report, which obviously that's not a status report, but each one of these people then can be given notice of doing a full deposition where they have to come in and answer questions under oath. So this is a really big deal. This is like really important. Well, you all know what I'm talking about, right? Did I need to go digging for it? Or do you know what I'm talking about? The other statements that they put into the court. I'm still looking for this here. Where'd they go? Where'd they go? Oh, no, that's... Okay, everybody knows what I'm talking about. Okay, well, never mind then. Let me put this back and get reading again. Diving back in. Can you explain briefly? Sure. All right, give me 1 second here. I need to find the ones that I'm talking about. Hold on here. I've been kind of all over the place with these documents. So, okay. No, that's not this case. Well, I'll give you an example of what it kind of looks like. Here we go. We'll compare it to another thing, all right? So when all this went down after the Supreme Court ruled their per curiam decision, basically they've had random people, well, these people, Cerna, Katz, Kozak, and Mazzara, have been writing out essentially affidavits. So they've been putting together like, I'm from ICE, I've been there 5 years or 10 years, and this is the information that I have. Absolutely not helpful information at all. And they've been filing that because they have to meet that requirement of filing a status report every day. So they've been absolutely useless. But what the court's saying here is that for each one of them that has filed one of those, they can get depositions for. So that's really big. This is big news right here because they have to be under oath. Now you might say, well, what about taking the fifth against self-incrimination? And they could, but that's going to look real bad. That's going to look really, really bad. All right, diving back in. So that's number 2. So by Wednesday, April 23rd, then we should know which ones they want to take depositions of. And then they have to make themselves available. So all these people have to come in and sit down with a court reporter and go through what they're saying, which I think is incredibly important because this guy in particular, Mazzara, is just citing what, I think it's Kotz. He's just citing what Kotz said. He doesn't have any new, fresh information. All right, number 2. So by number 3, by no later than Wednesday, plaintiffs may move for leave of the court to conduct up to 2 additional depositions of individuals with knowledge and authority to testify regarding the matters identified above. Defendants shall respond by Thursday, April 24th. If the court grants leave, it will set a deadline by which the deposition must be completed. This is huge. All right, so they can ask for 2 more depositions. This is huge because the 2 people they can pull in are Marco and Bondi. They can put subpoenas out and bring them in to come to the office, have a court reporter, and they can ask them questions. They are not protected by any privilege. I mean, they can say self-incrimination, but if we're in the middle of discovery and they're asking for a sworn deposition, they have to comply or they will be in violation of the court order. So this is how you chase these 2 down to put them in jail right here. All right, so if they wanted to, I don't know who they're going to want. The 2 best people for the case, and I don't know if these are them or not, but they could. They have the authority. This judge is giving them the authority to pull these 2, to pull 2 more people in to do depositions. Right. Oh, it's huge. And so Marco's like, well, I don't have to. Like, well, you do. It's a court order, actually. I mean, that's what it is. And he's like, well, I'm not going to say anything. Well, that's a different issue. But you have to come in and, make yourself known. You need to come to the office. So this is very important. And here's the deal. You might say, I don't think they'll comply. But how many people have gone to jail for not complying with a subpoena, right? So we've got Navarro, we have that other guy, what's his name? Bonner, what's his name? He's got that radio show, I guess. He's, big buddy of Bannon, thank you so much. Oh my gosh. That was a struggle, everybody. That was a struggle. All right. Thank you so much. Bannon, my bad. All right, so holy shiitake mushrooms. All right, so Steve Bannon and Navarro were like, we're not going to speak the truth or comply with subpoenas. They got put in jail. All right, so that is possible. That kind of a situation is. So if they do not, I did mentally block. I mentally block a lot of things here. I just do. But again, if they are subpoenaed, that is a court order. And if you don't comply with the court order, then there's a warrant issued from the bench, and she would have the authority to do that. Oh, thank you so much, John. That's an excellent reminder. All right. So this is very important, everyone. This is very important. She has just given authority to the plaintiffs to pull 2 more people in. First, she said, if you want these fellas to come in for depositions, you can do that. And if you want 2 more, let me know and we'll get that put together as well. Meaning sending out subpoenas, you need to show up, and if you don't, I'm going to issue a bench warrant. All right, so very, very important here. This is a huge win. Now, what I'm guessing is the government's going to come back and say, well, we don't have to do deposition because everything's classified. And what she's going to say is, well, you don't know. Maybe they're just going to ask what your name is. Is that classified? Or, what town were you born in? Is that classified? So you can share the information that's not classified. So you need to show up and be in front of that court reporter and swear you're going to tell the truth. So this can be an incredibly big deal. They really do need to be under oath badly. All right, so here is her concluding paragraph, everyone. To streamline review of any anticipated objections, well, that's going to happen a lot. The court will file a separate letter order regarding discovery disputes. The parties are to follow the procedures described in the letter for any disputes that cannot be resolved by good faith, meet and confer, which is probably going to not happen at all. At the conclusion of expedited discovery by no later than Monday, April 28th, plaintiffs will supplement their motion for requested relief. Defendants shall respond by no later than Wednesday, April 30th. The court will hold in abeyance plaintiff's remaining requests for relief until the completion of expedited discovery and supplemental briefing. So this is where she's saying, oh my gosh, this judge is so smart. So the plaintiff said, we've got contempt. We want you to hold a contempt hearing. That was one of their requests. And so she's saying, I'm going to order expedited discovery, and if they screw around on it, I'm going to order a contempt hearing, is essentially what she's saying in this sentence. All right, so that's basically what she's saying. She's like, I'm going to put a pause on these other requests, and we're going to see how they do. And if they do what they're supposed to do, then, we'll keep going forward. But if not, then I'll grant plaintiffs' other requests, which would, be huge. So that's important. That said, should defendants fail or refuse to engage in the above described discovery in good faith, plaintiffs are free to seek separate sanctions on an expedited basis. Oh my gosh. And then she said, now, if they don't comply, you can cut in line and come straight up in order for us to have sanctions requested here. So that's a big deal as well. Right. So let's look at the dates real quick and then we'll go through the letter. So the important dates, the first one is interrogatories, right? The interrogatories have to be delivered by tomorrow, I guess. I mean, that's tough. Well, maybe not. So by tomorrow, 5 p.m., 15 interrogatories. Those answers need to be given back to the plaintiffs by the 21st. By tomorrow, then, they need to give notice. The plaintiffs need to notify the court if they want to do depositions. So we should know tomorrow if they're going to do that or not. And then, if they are, those depositions have to be completed by the 23rd. So they have to hurry up and schedule this stuff. They've got 4, 5, 6, 7. They've got 1 week to schedule and do the depositions. Oh my goodness. This is pretty fast. We're fast tracking this. My gosh. And then Wednesday the 23rd, they can ask for 2 more. So after they finished the depositions they want to do here, they can ask for 2 more. And then defendants have to respond by the 24th. All right. So that's our schedule, and that is really fast. That's like whiplash fast for court. That's super fast. Yeah. No, she's not messing around. This judge is not. Oh, this judge is not messing around. He would have already had these. I know. Oh my gosh. All right, so let's take a look here quick. This is the last one that came out today. This is the letter order regarding the filing of discovery motions, because everything can get petty. every single sentence that's written in an interrogatory can be objected to. Every single filing can be objected to. And this could be put into a situation where it just slows everything up so much that it clogs up the actual docket. So, because technically that would be unethical, but these attorneys don't seem to mind. So, I'm just saying. Here's a letter order regarding the filing of discovery motions. To promote the just, speedy, and inexpensive resolution of this case, the following procedure will be followed with respect to the filing of discovery motions, such as motions to compel, motions for a protective order, motions seeking the imposition of sanctions. Any party seeking to file a motion must first serve on all parties and file with the court a letter, not to exceed 3 pages, single-spaced, that includes a brief description of the proposed motion and a concise summary of the relevant factual and legal grounds. The letter should include the positions of all parties. Parties shall attach to the letter the disputed interrogatories or requests for production and the answers or responses to the same. Okay, so this is taking us back, everybody, and I think it was the criminal case. Correct me if I'm wrong here, but I don't think it was the Angron case. Maybe it was Angron. I can't remember. Oh my gosh, everybody. But in one of the cases, Trump's attorneys kept filing all of this stuff, and the court finally said, you're not allowed to file anything more. You have to file a letter and get permission in order to file your motion. Do we remember? Was it Angron or was it the criminal case? Do we remember? I just remember reading like every single time they tried to file something, there had to be a letter on file, a letter of approval, which again shows that your judge is really pissed off. Was it Angron? Okay, thank you so much. Yeah, I was wondering. No, not. Was it Chutkin? Maybe she did it too. And it's very possible. It's very possible. But I remember we were actually in trial when I was reading the letters saying like blah, 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 blah. So that's why I think it was Angron or the criminal case. Yeah, I think it was Angron too, come to think of it. Yeah, so basically we've got the similar situation, and this is what happens. This is like the first level when the teacher writes your name on the board for talking too much, right? Hopefully they don't do that anymore. But this is the first level. She's saying, look, you need to put a letter in here before you start screwing my docket up. Because if you're just going to file stuff left, right, and center constantly, you're going to screw the docket up. You're going to, spend everybody's money because everybody has to have notices and then everything has to be filed again. And she's basically saying, I'm not going to let you get away with that. So you need to file a letter. And I think that's very smart. You don't? Okay, I'm glad to hear that, Anthony. I was worried for a minute. I was worried. Upon filing of the letter, the court will schedule an expedited telephone conference to discuss the requested motion and to determine whether the issues may be resolved or otherwise addressed without the need for formal briefing. So she's saying, if you guys got a problem, let's get on a telephone call instead of briefing it back and forth, right? Because briefing takes a lot of time and it's a tennis match, like one side, then the other side, then back again. So she's saying, give me a call. The telephone conference does not take the place of the party's obligation to meet and confer in good faith pursuant to the federal rules of civil procedure to attempt resolution of the issues without court involvement. If the issues are not resolved during the telephone call, the court will set a briefing schedule in consultation with counsel. Although informal, this is an order of the court and shall be docketed as such. And this is what you write when you know everybody's going to appeal everything all the time. Oh my gosh. Oh, this is great. This is a great letter. I love it. I wish more judges would do this, actually. So if we think about it too, the Department of Justice, the attorneys working on this case, for the next 3 weeks, they cannot work any other cases because every single day there's going to be something that has to be done and it's going to be significant starting tomorrow. Well, I mean, today they had a hearing, but based off of this schedule where you have 1, 2, 3, 4 depositions that need to be scheduled and done, depending on whether or not, this information is relevant, interrogatories have to be handed over and answered. And then 2 more depositions could be done. And then within both of these can be objections to questions or evidentiary issues, and so there could be telephone conferences. So the DOJ that is working this particular case is not going to be able to work any of the other cases, in my opinion. Who knows? I mean, I don't know what the pharmaceuticals are this time at the White House, but I'm just saying it's going to be a heck of a lot of work. It's going to be a lot of work. This is a lot of work. She got out ahead of it exactly, Kaya. Ooh, she did. She did. She got ahead of it. All right, everyone. So that's the last of the documents that were filed today. I do want to just kind of give you a heads up on a few other things that may help you kind of to go through this case and figure out what's happening. When we are talking about removal or withholding of removal under Section 241B3B, I was on a live with Legal Dad last night and several others whom I adore. I adore each and every single one of them. But one thing to remember is that this section is not really used that much, and so you may be unfamiliar with it. So this is this section of the law that they're talking about. Basically, you can ask for this in special situations where maybe you have missed the deadline or some other reason, but if you know for sure that bad things will happen to you and there's no way for you to return home, it's possible to use this section in order to, be able to stay in the country. And the one piece that I think is really important here is when they're talking about withholding of removal under the Convention Against Torture. Now, I'm going to just refer to this as CAT, but I think CAT has been brought up quite a bit in the JGG case, right? Our 5 top that was like, dude, you shouldn't be taking us to El Salvador without due process. This one's been brought up quite a bit by the judge there. So this particular section of the code I think is really important for both cases, but this is the section that was granted to Mr. Garcia. He was given a court order that granted this section of the immigration code for him so he could remain. They went through the analysis, and if you read that order that I did already, you'll see what the analysis was that supported why he should be allowed here. So future threat to life or freedom and so on. But I think that's really important. The other thing too is the convention, the CAT situation, that's a United Nations piece that we incorporated into our federal law. So that's basically a treaty that was signed, is how I would look at it. Multiple countries signed that treaty and said, we're against sending someone to a country where we know they're going to be treated in this awful way. So they're not supposed to do that. Now, the big piece with CATs is that the person sending them has to be aware ahead of time that they're the possibility of torture. All right. So my thing is I keep thinking about all the times and all of the publicity Trump has done with how awful the situation is in El Salvador. Like, there's no way he did not know that, or Marco did not know that torture was on the table. So that element was already in play. So the pieces to CAT, that treaty or that statute against terrorism or against torture, that those pieces are already starting to come into place. I just want to put that out there because there are multiple levels and multiple ways of going after different people involved here. All right. Yeah, I mean, we don't have confirmation except 2 days ago. We had that declaration of that guy that said, well, he's in custody. So he didn't, I don't know if you can use the word custody if they are not alive, but who knows? Because this is bananas. All right, so a couple more things, everyone, I wanted to share with you here for those interested in digging a little bit deeper in this case. If you pull this case up on Court Listener, the petition's the first thing that's filed, the complaint. Under that are multiple exhibits, and these are the exhibits that are under that. Now, I can't go through them tonight. I may at a later date, but I can tell already I don't have too much voice left. So if you're interested, we have an affidavit of Jennifer Stefania Vasquez Sura, right? Here, she's a citizen. She was born in Virginia, and she is the mother of the children. Uh, well, she has two children from a prior relationship and one biological child together. So, if you're interested in seeing what her information is, the affidavit that she wrote out, and how she's explaining things, I think it's really helpful. I think it's very interesting to get another set of facts in here. And of course, we always corroborate and put our sets of facts in different places. She signed this on March 23rd. All right, so this is very important and incredibly recent information. I know there's a lot of other information out there about his 2019 court order, which is great, but for this particular case, I think this is very important. So if you're interested, this is one of the exhibits next to the petition. All right, so we also here, this is another exhibit where we've got the audit. Here we've got two affidavits set out. Oh, there we go. Here is something else that's an exhibit, everyone. And I thought this was really important too. Let me zoom in, okay? Let me zoom in because what we have is an order of supervision. So even though he was, the code section that said he is not to be removed, right? So the withholding of the removal didn't mean he didn't have to go in and work with the people still. He still had to go in each year, 1 year at a time and talk to the people. All right. So this is the record of him going in and talking to the immigration people. We have it started October 22nd of 2019. So here in 2020, he went in 8 a.m. 2021, he went in 7:30 a.m. I guess. 07:30. Looks like we're missing 2022, but we do have 2023 here. Next report due, that's what NRD means. Here's the report there, and then 2023. Oh, sorry, 2023 I just said, and then 2024. So he went in, except for 2022, and I'm not sure what happened there, but he went in and checked in and spoke to who he needed to speak to. He wasn't trying to hide. He wasn't trying to do anything. According to this log, he went in and did what he was supposed to do. So just remember that. When we're looking through this and we're saying, well, he's just trying to get out of something. Well, he's not. He's not. This is also showing, again, he has no ongoing, no open cases going on. Again, this is all part of the exhibits that were put into the complaint at the very beginning. And then this is the 2019 decision. I've already read that. So that is available. Again, this is available if you just want to listen to it rather than reading it yourself. And then I'm going to show you a couple pictures, everybody, all right? They're not too bad. I'm giving you a heads up first. These, again, are exhibits included here, all right? So this is the first picture, and they've circled him, right? Because they can tell because of the tattoos. So they have confirmation that he actually is there from this photograph, all right? So that's the first one. And again, this was part of the file. Here is another picture of him here. Again, identified by his tattoos as well. Here, so that's not a good situation. And then here's just another photograph close up on his tattoos to show he is there. He is there. So there you go with the photos. I like to do visuals, but that will probably be my only time of sharing those visuals with anybody. So there you have it. Oh, I know, it's absolutely atrocious. And again, everyone, to remind you, this cat situation, I think, is really going to be incredibly important. We haven't really been talking about it a lot, cat, and a lot of people don't really understand what it is. I certainly didn't understand what it fully was until I looked into it, but it absolutely is in play here. And again, that's that treaty signed. Oh my gosh. Oh, Woody. Oh, that's so sweet of you. Your moderators are on power trips. Oh, we love them. We give them extra power. Remind them that fruitful discussion and differing opinions doesn't mean I'm the enemy. Well, God bless to you as well. We have to be careful here. I will say my moderators, each and every single one of them, I trust absolutely here. And I also, they've been working with me for such a long time. They do great work. So, with that, I don't really do debates during my lives because I'm giving information out more. I do have, my moderators will chat back and forth, but I've spoken to each and every one of them and told them where my line is. And so, they are absolutely doing what I've asked them to do. So, moderators, you're doing great work, and it looks like the Woody fella, Woody Wooder, wasn't very happy. But such is life. Lots of people aren't happy right now. But to my moderators, you're amazing as always, and I adore you. So, let's jump back into the torture, all right? Next, here again, the cat piece of it is a treaty that was signed, and it is a UN directive. So, this is important to keep in mind. Oh my gosh, we love our moderators here. We do. All of my moderators are amazing. I, you know, I'm so thankful for the moderators. I wouldn't be able to do this without them. Right. But hey, if you want to support the work here, that's enough to buy half of a toner cartridge. So yes, they are great. I agree, Lisa. I agree. Sounds like he was I know, I need to pay the mods. I wish I could. I wish if I made enough, I would. And I've got a little chart. I'm like, if I meet this milestone, then I could. But unfortunately, I'm not there yet. Yeah, we're not here for BS. And again, this is something too that a lot of people don't realize this, that I'm here to inform and not to debate. And my moderators protect me and they protect the chat, and I'm forever grateful. So, yeah, I agree, blunt psychologist. We have to remember, what's going on. We have to talk about it and the legality of it too. But also, everyone, there has been, and this is something I wanted to talk about too before I let you go for tonight. Again, this is like you're like in my classroom. I'm keeping you from leaving. Don't grab your backpacks yet, everybody. All right. One thing I want to remind everybody is that, it seems like this meeting in the White House with the that president guy and Trump really triggered a lot of people, and it pushed everybody into this like, oh, we're in a constitutional crisis for real right now. All right. And or this is it, this is the day democracy died. And I just want to say, I understand the fear. I mean, that was me March 17th at 5 in the morning. But on the other hand, too, I mean, this is spread out. This isn't just one situation. This is a huge situation. We've got lots of cases where the judges are starting to smack everything down. So I think it's important to know and remember this is a really, really, really slow process. And this expedited discovery, this is super quick. I haven't seen discovery this quick and this huge before at this level. But the judge understands. I mean, every day that he's in there is not okay. But also, on the other hand, we have to be super careful so that the Supreme Court can't come back and say, well, you didn't give enough notice, or, well, this wasn't served. You want to make sure every single piece of it is absolutely perfect. And that takes time. That does take time. But we'll see how it goes. The constitutional judges and SCOTUS. Right. Well, I don't know that the term constitutional crisis is one that I personally use a lot. I think, and I've said this earlier when I was doing my pregame show over on TikTok, that the three branches of government are like siblings and they absolutely fight. They fight sometimes, and sometimes they're really kind of cruel to each other, actually. But that's not an excuse. But the fight itself doesn't necessarily mean there's a constitutional crisis. What I see happens a lot with the Constitution is that we need clarification, that there's a hole
there's a hole in the Constitution or a water blot somewhere when they wrote something and it got blurred out. And so we need to tighten up what that piece of the Constitution means. And that's not a good or a bad thing. It's just something that has to be done. We have to firm up the language in the Constitution to make it usable for what we need today. So, yeah, the constitutional crisis. I mean, I don't know. Maybe I'm thinking, because when I think of a crisis, I think of, like the Civil War or something along those lines. Like that's, or not getting somebody out of office. Like the FDR situation, that was a constitutional crisis, I have no doubt, for the people at the time. They're like, why is he back in here again? When's he gonna go? So, and then we had to pass amendments. So I think that the crisis element of it, we're definitely fighting right now. We're having a big, huge fight, and it's ugly. I think that that is definitely appropriate. Mr. Garcia crisis, absolutely, absolutely. Revoke immunity. So, Chris, I think that's a great question. One thing to always remember, I always give two examples when it comes to immunity, all right? The Supreme Court can reverse itself. So let me give you an example. Back in the 60s, the U.S. Supreme Court had held that the death penalty was cruel and unusual punishment under the Eighth Amendment. So no death penalty for any case whatsoever for a couple of years under, I think it was a Furman case. And then we had the Gregg case that came a few years later. And the Supreme Court said, we were wrong. It's okay. Go ahead and have your capital punishment. All right. So that's one. The second one here that I always remind people of as well is the Chisholm v. Georgia case, where that was one of the very first cases where the Supreme Court said, Georgia, you're in the wrong, come to court, pay your debts. And Congress was really scared of that. So they passed the 11th Amendment to overturn the judge's decision in the Supreme Court. All right. So those are the two examples of how Supreme Court precedent can be overturned. All right. So one, somebody needs to bring a suit in front of them again with the same question, or two, a constitutional amendment has to be passed. Yeah, I mean, yeah, Roe v. Wade. Yeah. How is the misogynism out tonight? Did we not put out the misogynism repellent candle? Oh my gosh. You're welcome, Chris. You're absolutely welcome. And I'm not sure how to kind of get this information about the immunity out any better. People are asking about it so much, and it's because they're worried about it, and rightfully so. And so I keep thinking, like, is there a way to get this information out? And I guess all I can do is say, just, hey, everybody, pass it on. Pass it on, everybody. Serve a third term. Yeah. I mean, I don't know how that third term would work. We've talked about that a little bit, like, yeah, but I just don't even, I don't know. They follow me sometimes. It's okay, Jack. That's all right. I will not ever say I hate somebody or I dislike them or I don't want to talk to them just because they're part of a party. I won't say that because I think people are people, parties aren't people, right? So everyone gets a shot, but I'm rarely surprised by what happens after that. I'll say that. Hasn't held anyone in contempt. There's a whole process, Kim. It's a whole process. So we have, just like any criminal case, any civil case, you have the request. So one party says this party's in contempt of court, and then they say no, we're not, and then the court says let's have a hearing, and then in the hearing there are witnesses, there's evidence presented, opening statements, closing statements, questions from the judge, and then at the end of that the judge decides whether or not there was contempt. So contempt is just a mini trial within a bigger trial. So it takes a lot of work. It takes a lot of work to go down that road. Not that it's not worth it, because it is. It's just not a quick road. It's a road that takes a bit to go down. And I feel like this particular judge is like, let's get this going. As long as they do what they're supposed to do, you're going to be okay. But I think this judge, is on the verge of being like, I've had enough. Pass an amendment. Yes, exactly. They'd have to pass an amendment, or there'd have to be an issue raised and brought to the US Supreme Court. And actually, that may be an easier way for them to do it right now, because we've got, I don't know, what, 8 cases on interlocutory appeal that have gone up to the Supreme Court. Any of these cases here, they could kind of pull a side note and try to figure it out if immunity is raised in any of the cases that are being argued. So, like the Wilcox Harris case is in front of the US Supreme Court right now. And they mention immunity. They put immunity in everything because it's their favorite word. So, because it's their very favorite word. So, it's possible the Supreme Court could be like, oh, and just to clarify this, it's possible. Is it likely? No, but possible. Amendment never. We're not going to get any kind of an amendment passed right now. There's no way we're going to get any constitutional amendment through Congress. That was one of the things after the election that happened in November, was to remember there's no supermajority. I mean, there's no 2/3. So because of that, there's no way to really push that amendment through. Right, right. Mm-hmm. Yep, yep. Yes, indeed. El Salvador president to build more prisons. Right. But that's another thing too, everyone. If you think about it, I I think the fact that he spoke that way and said those words is incredibly offensive and worrisome, incredibly worrisome. But also I would remind you, he promised to build a wall. And what happened? Right? Like he makes a lot of promises to build stuff or ask people to build stuff, but the follow through just isn't there. So, it's like we can, say, well, we're going to build a supersonic jet to jet people over the Bermuda Triangle. That's where they're going to be held in a cloud prison. But for Mr. Trump, until it actually starts happening, I'm not going to believe it. I'm just not going to believe it. I will say, if he says he's going to do something and then he clearly doesn't, I'm going to call him out on that. But other than that, yeah. Yeah, he's struggling. I would absolutely say he's struggling right now. I think he's in bad shape. Also, I just from watching how he's responding to questions with the reporters is all I have to base my knowledge off of. So, and I'm not a mental health person, but based off of my life experience, he's struggling to leave if he did not win against Biden. Oh, well, sometimes our dreams crash and burn. Oh, sorry. Dehumanize. Well, he dehumanizes everyone, right? Everyone. It doesn't matter who. Nancy Pelosi has been dehumanized. I mean, whatever. That's the quickest, easiest way to get a pack against certain people is to dehumanize them. His physical was yeah, well, that I don't know about, and I'm not sure I want to know about it. I haven't actually looked into that at all because I'm just like, that's kind of gross. Yeah, I don't want to know that. I am a mental health person. I will say he has dementia. All right, ding, ding, ding. That's the winning comment tonight. You all have done great, but that one's the one that I think we had a winner, chicken dinner. That would be it right there. Oh my goodness gracious. I love that. So the signal leak, there's nothing really going on right now. There has been a lawsuit filed and it's slowly on the path. So we still have I don't know, 20 days before the next thing needs to be filed in the case, but it's ongoing. It's open and it's ongoing. He paid for the health report. Well, yeah, I mean, right. The findings are improbable. Kamala would have been amazing. And she still might be. You never know. You just never know, everybody. You never know. Fails to mention him being, oh, that's interesting, June Marie. That's very interesting. Huh. 4%. I don't know. I don't know anything about that. It's kind of like, I wouldn't want to know my gross grandpa stuff either. That's kind of how I see it. Yeah, it is. It is painful at this point. I think we're just, we have to make sure that we don't get flooded. We don't need our zones flooded with orange pain. So you just have to make sure you step back, right? You need to know what's going on, but you also step back a little bit and take a break, go touch some grass, play with your cats or your dogs or the chipmunks. I mean, I don't know. I don't know what kind of animals, forest creatures that you have around you. But yeah, don't forget to step away. That's important. Height and weight on that. And NFL, I just don't. Yeah. And the thing is, though, what gets me about all of this is that he can kind of do whatever he wants with his health report. Meanwhile, there are people out there, begging to have doctors listen to them and help them and not gaslight them. They're like, please, I've been trying to get an answer for 15 years. Meanwhile, he's like filling out the form himself, That's the moment where I'm like, what? What? Yeah, Cloud Prison. Oh my gosh, the Care Bears. Well, there was an episode, right, when the Care Bears turned evil and they used the power of friendship in order to turn good again. Oh my goodness gracious. Badger and the Cougars, of course. Why not? Why not? Right? Why not? Why not? Oh my goodness. Really, really. Oh my God. Yeah, I mean, he just filled it out himself. I mean, come on, right? 7 years. Yeah, I mean, it's hard work going through the process. It absolutely is. And if you're not, a textbook example of something, good luck. Good luck with that. Now, with that, my dears, my friends, my wonderful moderators, everybody, I will go ahead and sign off for tonight. I'm glad I can make it Tuesday. I'm going to try to do the Tuesday, Thursday, Sunday evenings this week. Everyone, fingers crossed. I'm working really hard. That's my goal here in April to do over here on the tube. So I will continue to post updates. If you want to know like a quick update, what just happened, it gets posted first over on TikTok. But then usually within an hour, I will post over here. I'm also on the Blue Sky, the Skylight. I'm trying to make a comeback. It's not a very good comeback. And then I go and I hang out on the Substack too, although I don't understand it, but I still go and hang out. So whichever flavor tips your tipper, feel free to join. But with that, I'll sign off for tonight. Thank you, everybody, and moderators. A special thank you to all of you. You know I adore you all. Have a good night, everyone, and I'll see you again very soon.